developments and dispute management. It's my favorite session of this conference every year, and so I'm thrilled to be moderating this panel with a really stellar cast of folks here. And so I'm going to go down the line with brief introductions. We have Kardon to kick us off, a senior fellow at the Carnegie Endowment for International Peace. We have Jacqueline Espenilla, who is a senior fellow with the Institute of Maritime Affairs and Law of the Sea at the University of the Philippines. We have Nguyen Thi Lan Huong, who is an assistant deputy director of the DC Institute with the Diplomatic Academy of Vietnam, and Liu Xiaobo, who is a director of the Center for Marine Studies at the Grandview Institute in China. So ground rules, we'll have each panelist deliver 5 to 10 minutes of remarks. After that, I'll open up for Q&A. If you're here in the in-person audience, Monica, my colleague, will be coming over with the microphone. Please feel free to raise your hand if you have a question. We just ask that when you do ask your question, if you could repeat your name, your affiliation, and stand up if you're able to. If you're joining us online through our virtual audience, there's a link on the CSIS website where you can enter your questions. So we're looking forward to having folks engage that way as well. With that, I will kick it off with Isaac to begin.
Thank you, Andreyka, and thanks to CSIS for having me again. It's Greg Poling in particular. This is my third appearance now at this grand institution here in DC of the South China Sea Conference, and every time there's something new to learn, and we are both fortunate and unfortunate that the situation continues to be dynamic and interesting. So it's a pleasure today to offer a couple reflections on, I think I'll focus on legal developments rather than dispute management, and maybe we can pick up that latter piece as my distinguished panelists discuss it and in Q&A. But I think that, as we discussed in the last panel, some of the operational details of what's been going on, particularly in the area of Second Thomas last year, and now increasingly around Scarborough, have been the center of focus on legal developments, and I would argue also the site of the most significant practical changes in the claims and the practices of some of the key states. So I'm going to focus on China, Philippines, but I'll be more than happy to expand and consider other issues in the region. But I think I would date the most interesting developments on the legal front to November 2024, when perhaps people in Washington were otherwise distracted. The Philippines passed new legislation on the 8th of November, a Maritime Zones Act and an Archipelagic Sea Lanes Act. The former of those is probably the most significant from a legal development standpoint, which basically put the Philippines' maritime zone claims, its entitlement claims, which is to say the main focus of the 2016 arbitration, which I'll get back to, put that squarely into their national legislation without any ambiguity about essentially the implementation of that award. And we'll come back to what the really key feature of that is, but I'll stress it here now, which is that there are no islands that rate a 200 nautical mile EEZ or a continental shelf in the Spratly group. This is the key finding from my standpoint that has a sort of substantive application to lots of different elements of South China Sea disputes, and that was enshrined in the Philippines domestic law. Now, lest we be misled into thinking that China is inattentive to the law of the sea or doesn't care, we should note that within 2 days, China published its own baselines in the South China Sea, not covering all of their claims as the Philippines had done, but continuing this piecemeal approach that we've seen from the PRC, starting with its 1992 territorial sea law, territorial sea and contiguous zone law, in which it only designated the Paracel Islands in the northwest of the South China Sea with straight baselines, and later went on to publish separate baselines for the Senkakus in the East China Sea, and we still have no Chinese baselines on the Spratlys, but we have this very interesting and somewhat more modest claim from November 10th, which is just baselines more or less around the low water lines of Scarborough Shoal, encompassing the entire lagoon and formally excluding the Philippines from accessing these now internal waters, and a sort of a very direct reneging on what might have been the only small area of Chinese compliance with the 2016 award, which was allowing some degree of Philippines fishing in that shoal. Subsequently, within a couple weeks, China deposited these charts to the UN, and this triggered a United States reaction. We have a U.S. note to the UN General Secretary or Secretary General rejecting the PRC's baseline practice, particularly on this question of outlying archipelagos. And we don't need to go into this in great detail now, other than to say there was a very long and very thorough State Department limits in the seas from the year prior, evaluating not only the law under the law of the sea, but also state practice, whether or not there's some customary norm in which states were drawing outlying archipelagos. And I will spoil the ending. The U.S. State Department does not think so, whereas China, of course, does think so. China took a little bit of time in responding to that, but ultimately by February 2025, China also wrote a note to the UN objecting to the U.S. baseline critique. And an important element of this statement is, quote, China has yet to draw its territorial sea baselines for other archipelagos. And I think that's a not so subtle signal that we should expect baselines in and around the Spratlys at some undetermined point in the future. And we've certainly been expecting these ever since the beginning of China's decision to ratify UNCLOS in 1996. But I'm still waiting for that, and the good folks at AMTI have done a really nice job of mapping out what some of these might look like. Another really important thing about what the PRC said, which is not so much a new legal development, but I think a crystallization of what the PRC's overall practice in the law of the sea has been, is that they say essentially questions about baselines, and in particular these archipelagic straight baselines, are, quote, matters not regulated by this convention. And here they're drawing from the black letters of the treaty and trying to basically interpret the law of the sea to not be a quote, constitution for the oceans, but rather a statute that covers certain issues, and the rest is left to what they'll often call general international law or customary international law. And I think that's the overall direction that we've seen in Chinese policy on law of the sea issues, which is to say narrowing the scope of the law of the sea convention, finding ways to read into it the idea that this is not the covering law, that it admits lots of different types of state practices, and that over time, my understanding is the Chinese theory of the case is that you can gradually crystallize your practices into something that would be recognized as a customary rule. Now, of course, we have a lot of objections to this. The U.S. State Department has objected to that on numbers of occasions, and of course, the Philippines and other claimants in various forms of their practice, whether it's their domestic legislation or their own comments, have rejected Chinese claims more or less across the board. So we're at somewhat of an impasse from the standpoint of international law. And I think that leads many people in, not just in Washington, but in the region, to sort of throw their hands up in dismay about the lack of efficacy that you find under international legal mechanisms, in particular things like third-party dispute resolution as provided under the law of the sea, and as exemplified by the 2016 South China Sea arbitration, which of course the PRC did not honor. What I'd like to say in just the last couple minutes before turning it on is that despite that cynicism about international law, and I think despite the current administration in Washington's relative lack of interest in the subject, I think there's a lot that can be done within the region among regional claimants, and ideally with U.S. support and coordination, to provide for what we might call the great rejuvenation of the South China Sea arbitration, which will, of course, have its 10th anniversary next year, right around the time of this conference. And so maybe we'll have to a celebration or a funeral then over whatever the status is of that arbitral award. But to my mind, as I said up front, the really key and substantive finding in that I think enjoys very broad regional buy-in in terms of formal statements from regional states as well as their national legislation is this fundamental idea that none of this tiny islands and rocks and reefs and submerged features in the South China Sea is entitled to extended zones. Now, there are lots of elements of the award and lots of elements of the maritime policy of the other regional states that, among the regional states that are not shared. And we don't need to look any further than the fact that Malaysia objected to the Philippines laws as well on the basis of their longstanding dispute over Sabah. And this is just one of many potential areas where it's very difficult for regional states, regional claimants in particular, to take a look and say, this solves all of our problems. But what I'd like to offer is that there is a lowest common denominator. There are elements of this award that reflect a consensus view on the law of the sea, on the application and interpretation of the law of the sea convention in particular. And where I'd like to focus our attention, I don't have a map here, but you can use your mind to imagine 200 nautical mile zones from each of the coastal states from their continental from their major land masses, and China is extending from Hainan. And what you will see is that there's what former Indonesian foreign minister as long ago as 1994, Indonesian foreign minister Atlas called the high seas donut hole. And this is an area which, under the terms of the award, as well as under the terms of each of the coastal states' domestic laws and their interpretation of the law of the sea, is an area where nobody should have jurisdiction. Similarly, under the arbitral ruling, the arbitrators found that the 9-dash line or the dotted and dash line doesn't constitute a claim to historic rights. I'll make a sort of PSA here, which is to say it didn't invalidate the 9-dash line as a claim to sovereignty. And all of my comments here are agnostic as to that subject. And what I'm suggesting is you can follow Deng Xiaoping's dictum to shelve disputes and pursue joint development, retain your sovereignty claims, but start to focus on these areas that are less problematic among the claimants. So this high seas donut hole isn't huge. It's about 5% of the overall surface area of the South China Sea. But within that area, there's tremendous scope for cooperation among not just claimant states, but any state that wants to navigate there. We're all familiar with high seas freedoms, particularly as they apply in the EEZ, which is to say they include freedoms of navigation and overflight, laying submarine cables, artificial islands. All of those are appropriate, and those can be done separately or jointly. But I'd note that there's actually a lot of interesting things that can be done that have not been tried. Now, artificial islands are usually thought of, or the typical application of them is for resource exploitation. That's much more problematic in the high seas, and what we should be thinking about is there a possibility of doing things like joint scientific research in that space? Artificial islands can be built for all manner of purpose, not unlike the way that China's built a number of structures in the Yellow Sea that can land helicopters and that are for fisheries monitoring. These are all legitimate uses of your high seas freedoms. Similarly, fisheries management. There are regional fisheries management organizations that can focus on that high seas comma or that high seas donut hole for their activities. Similarly, marine scientific research. We also have another treaty that is gaining popularity and should be ratified by everyone, including the United States, which is that BBNJ, or the High Seas Treaty, that opened for ratification in March 2023. And here we have the possibility of things like marine protected areas, environmental impact assessments, and a variety of other things that can be conducted lawfully and in line with all the coastal states' interests, with the exception of China, which is in an awkward position in this case of being the only one who mounts a claim to any jurisdiction in this space. And I think this is an area of legal development that China has sort of been boxed into by virtue of the arbitral award. Prior to 2016, we didn't see a lot of clarity from China on the nature of some of these jurisdictional claims, but the precision of the award and the precise questions that were asked really generated a lot of discomfort in my assessment in the PRC. And despite the rejection of the award, there were a lot of reactions to the award. And I think that the fact of the PRC's sensitivity to this, the fact of the PRC's demonstrated willingness to not just react, but to make somewhat more modest claims, as we might see in the Scarborough Shoal case, I think are really important and telling indicators of ways that peaceful management of these disputes can proceed. And I would argue as a final note that we've been doing this for some time now, and there have been, in the course of the South China Sea Conference here, 15 years, if I have it right, that would take us to 2010. No major militarized conflicts in the South China Sea, and yet what we're seeing over that period of time is an increasingly intense pattern of what's typically called gray zone coercion by the PRC, and this really culminated in terms of its effects in June 2024 with the dangerous encounters around Second Thomas Shoal. And I'll offer that this salami slicing technique that Beijing has been using for a long time can't continue indefinitely. And I think that was an illustration of finding something like close to the ceiling of what's possible if your goal is to use tactics that are non-lethal. A way of applying this salami slicing metaphor is that there's only so much salami you can slice before you cut your hand. And we saw very literally that happened to a Filipino sailor and take us really precariously close to conditions that would have warranted invocation of a mutual defense treaty and potentially started a major escalatory cycle. So I think there's not a lot of headroom. I think there are a lot of conditions now combined with the tension in the Taiwan Strait that make the South China Sea especially problematic. And I think there's a lot of urgency now to try and find some cooperative mechanisms that prevent China from breaking apart the shared interests of the various coastal states, and particularly the claimant states, and start to think about some constructive things that we can do together. So let me break there and turn to my panelists, co-panelists.
Thank you, Isaac. And that was a very helpful overview of some of the more legal developments that have been happening over the past year. And I feel like you've also given us ideas for a menu for next year's South China Sea Conference with salami slicing, high seas, donut holes, getting us hungry right before lunch. So I'll pass it over to Jackie to continue.
Thank you. And thank you for having me join this panel. I was actually supposed to join the 13th session, but unfortunately couldn't make it that time, so I'm finally here. I just wanted to say that I agree with much of what Isaac has said. I agree so much that, in fact, many of my prepared remarks tracks his issues very, very closely. So bear with me as I do revisit some of the things that he said, but also offer some of my own observations as regards those. So I want to begin my statement by saying that the last couple of months have been all about action and unwarranted overreaction in the South China Sea. And what do I mean by that? As mentioned by Isaac, in November 2024, our President Marcos signed two important pieces of legislation, the Philippine Maritime Zones Act and the Philippine Archipelagic Sea Lanes Act. I want to emphasize that together, they enshrine in domestic law the Philippines' continuing adherence to UNCLOS in the determination of its maritime zones, as well as its rights and obligations in relation to those zones. Of equal importance is the fact that the MZA formally incorporates the outcome of the 2016 Philippines versus China arbitral award. And to be clear, the adoption of the MZA and the ASLA are both sovereign actions of the Philippines and are compliant with its international legal obligations under UNCLOS. If you'll read the text of both of these laws, you will see that it it takes a lot of effort. It took a lot of effort to pin its provisions to specific provisions of the UNCLOS as well, demonstrating that it really is in full alignment with this international treaty. And I also want to emphasize that many other ASEAN countries have enacted similar laws over the years, telling you that this is a perfectly valid action on the part of the Philippines as a sovereign coastal state. As mentioned also by Isaac, just 2 days after that, China declared straight baselines around Scarborough Shoal from which a territorial sea demarcation can be based. The apparent purpose of the declaration was, of course, to oppose the MZA's inclusion of Scarborough Shoal and to lay the basis for engaging in stricter enforcement actions in the area, including stepping up maritime patrols. From a legal perspective, China's declaration didn't really do much to change the status quo on the ground. However, it is still noteworthy that it potentially indicates China's abandonment of its Four-Shaws offshore archipelago theory, at least insofar as it concerns Scarborough Shoal and its being part of the so-called Zhongsha Kundao, which includes the fully submerged Macclesfield Bank. A couple of additional things to point out is that the South China Sea Arbitral Award classified Scarborough Shoal as a rock, fully within the Philippine EEZ and continental shelf under UNCLOS. As such, it is not entitled to anything more than territorial sea and cannot generate its own EEZ projected from these baselines. Second, the award explicitly required Scarborough Shoal to be open and accessible to traditional fishers, whether they be Filipino or Chinese, regardless of who has sovereign control of the shoal. China has engaged in access and area denial in that area since 2012, though Filipino fisherfolks have still managed to fish along the exterior of the reef. Stricter enforcement actions to the further exclusion of Filipino fisherfolks on the basis of these new baselines will be a total violation of the award. So now China's overreaction didn't stop at drawing baselines around Scarborough. From January 2025, we have tracked a noticeable uptick in Chinese air and sea activities that are clearly meant to harass and intimidate the Philippine government. First, there has been an increasing number of incursions by Chinese vessels into Philippine jurisdictional waters. Not only have they maintained an almost constant presence within 82 nautical miles off the coast of Zambales province since early January, they have also been venturing deeper and deeper into Philippine archipelagic waters, possibly to normalize archipelagic transit passage where there wasn't before, and to lay the basis for claiming that its unusual new pathways are, quote-unquote, normal passage routes used as routes for international navigation and overflight, end quote, from UNCLOS, and thus should be included in the Philippines' ASL designations. One news outfit has labeled this silent presence in non-routine waters as, and I quote, loitering with intent, end quote, maintaining physical presence in an effort to reinforce and normalize its claims. Second, China has continued to engage in dangerous and unsafe vessel behavior in the South China Sea. Of course, this is not new. In August 2024, as mentioned in the earlier panel, a collision happened between Philippine and Chinese Coast Guard vessels near Sabina Shoal, and the Philippine vessels were in the middle of a standard rotation and resupply mission when the Chinese vessels dangerously approached and eventually rammed the PCG vessel, tearing a 3-foot wide hole in it, which constituted the biggest structural damage to any Philippine vessel up to that point. This was particularly distressing since the incident occurred after a provisional agreement for the safe conduct of Philippine RORE missions was agreed by the two countries in July. Now we fast forward to 2025. Just this April, a 99-meter CCG vessel sailed dangerously close to a 44-meter PCG vessel and even cut off its navigation route. The PCG vessel was conducting a routine patrol off the coast of Zambales, just 36 nautical miles south of Scarborough Shoal. On May 21, 2 CCG vessels shadowed, fired water cannons, and sideswept a civilian Bureau of Fisheries vessel that was conducting MSR activities near Sandy Cay, which is located within the territorial sea of the Philippine-controlled Pag-asa Island. These encounters all demonstrate China's continued non-compliance with coal regs, which, as clarified by the South China Sea Arbitral Tribunal, is binding on China as a state party to that instrument, and also because the coal regs are incorporated into the UNCLOS via Article 94. I also want to stress something that the tribunal said, and I quote, "Where the operational requirements of law enforcement ships stand in tension with coal regs, the latter must prevail," end quote. So even if China asserts that its vessels are engaged in what it believes are law enforcement actions, this is still no excuse to set aside its coal regs and UNCLOS obligations. In other words, the tribunal stated that law enforcement actions are not without limits. Third, the new trend seems to be China engaging in unsafe aerial maneuvers near Spratlys and Scarborough, and again, this was also pointed out in the earlier panel. This exponentially increases the risk of a deadly collision in the skies. There were 2 encounters in February this year. First, a Chinese military helicopter flew and hovered within the unsafe distance of 10 feet of a small Philippine Bureau of Fisheries plane carrying journalists, and which was just conducting an MDA flight. The Philippine plane issued at least 19 radio challenges, but they were all ignored. Second, 3 Philippine aircraft, again on routine surveillance missions, were harassed by Chinese military aircraft engaging in dangerous maneuvers, this time over the Spratlys. These 2 incidents pick up from the August 2024 aerial incident mentioned this morning, where Chinese aircraft dropped flares on the flight path of a Philippine military patrol plane conducting a routine surveillance mission near Scarborough Shoal. These maneuvers are blatant violations of customary air rules, including those found in the ICAO's Chicago Convention Annex 2. I want to end by highlighting the Philippines' possible next steps. It will likely continue its ongoing transparency initiative in the South China Sea. This strategy has been critical in rallying both domestic and international support for the Philippines, even as it may be seen by some as being provocative to China. In that sense, the strategy has had its value, but of course it also has its limits. And I emphasize, it is just one tool in the Philippines' arsenal against Chinese activities and disinformation. A new legal case might also be initiated down the road. I emphasize might, because this is still an option that is being carefully studied. One idea that has been floated is that a future or potential case might be on the basis of environmental damages. So this is something that we will be closely monitoring. On the code of conduct, President Marcos has urged other ASEAN countries to accelerate its adoption. The Philippine government has, however, noted that there are still several unresolved issues, including the scope of the code, whether it will be binding, its relationship to the 2002 DOC, and other key terms. And now I want to end with just a quick reaction to the donut hole comment. The BBNJ agreement is certainly a historic instrument as a third implementing agreement to UNCLOS. I, for one, hope that it will be ratified soon by my country and that it will enter into force. We're at 51 right now, and hopefully the race to 60 will end soon. One important aspect of this, and I fully share Isaac's view here, is that it emphasizes once again that there is a donut hole in the middle of the South China Sea, a high seas pocket, which in theory implies that the BBNJ agreement and all its provisions would apply to that space as well. During the negotiations for the BBNJ agreement, China strenuously disputed the notion that there is even a high seas pocket in the middle of the South China Sea, going so far as to ensure that there is wording or language in the BBNJ treaty stating that any disputed waters would be taken out of the application of the BBNJ agreement. The implication, of course, there is that the South China Sea would be taken out of the application of the BBNJ agreement. Of course, I have a problem with that, and I'm sure many of you will have a problem with that as well, for the simple reason that the core goal of the BBNJ agreement is to ensure the conservation and sustainable use of resources in the high seas, including the middle of the South China Sea. By taking it out of its application or the scope of the treaty, you're effectively saying that no protection can happen in that middle of the high seas pocket in the South China Sea. What does that mean? No area-based management tools. MPAs cannot even be considered by the Conference of Parties for purposes of protecting or reacting to any environmental issue happening in that area. Environmental impact assessments as well will be very difficult to carry out there under the aegis of this treaty, simply because it is being characterized as not a high seas pocket and being entirely jurisdictional waters within the 9-dash line. So that will be a problem, as you can see. So I will end my comments here, and I thank you, and I look forward to your questions.
Sorry, thank you very much. I think we're going to stick with the order in the agenda and turn to Xiaobo next, and then close out with Lan Huong at the end. So, Xiaobo.
Yeah, thank you. Thank you for your host, and thank you, Greg and Harrison, to invite me. It's a great honor to be here and for the second time and long time. And I know China will be the target at the South China Sea, but please then let me share my personal view about from a Chinese scholar. And all my presentation, I must say, not represent any Chinese official position and have no relation with my working experience in Navy. And today I want to share my three view about the South China Sea, China's South China Sea policy development in the last year. And the first, and as you have mentioned, China announced the territorial baseline in the Scarborough Shoal, and I personally think is a reaction to react to the Philippines and announce the Maritime Zone Act in November, and after that, and as the Philippines claimed, reiterate claim of the Scarborough Shoal and some part of the Spratly Shore as a Clarion Island, China to announce that territorial baseline on the Scarborough Shore. It's very meaningful, and because I think first, that's the meaning China have declaimed that the outer limit of the 12 nautical miles of territorial sea and of the Scarborough Shoal. And so it's very helpful for the Chinese Coast Guard and the Chinese Navy to conduct operation and law enforcement and in the territorial sea and in the national airspace of the Scarborough Shoal. And it's a very tough action. And so that means that the Chinese Coast Guard and the Chinese and the Navy or Air Force can do every measures to self-defense his territorial and sea and territorial airspace. And the second, and I think the meaning is that China use a territorial street territorial baseline, and as China is the domestic law, and I personally think maybe it's very difficult to draw the street baseline in the Scarborough Shoal, because the Scarborough Shoal is a very small part of the Zhongshan Mackless Field Bank, but as China insists the domestic laws, maybe that's the territorial baseline in the Scarborough Shoal made the precedent for China will do in the Spratly Island in the future. That means that as China claimed as a group of the Spratly Island, and maybe in the future China will select some features as a street base point to draw the territorial baseline in the Spratly. But as China didn't select the underwater features in the Mackless Field Bank to be the street base point, so it's a very difficult challenge for China to select some features in the Spratly Island, maybe not including as an underwater feature as a street base point. That's a meaning for the territorial baseline in the Scarborough Shoal. And also in November, China have announced the official number of the features in the Southern Sea. It's 64 features, the official Chinese number. And in the same month, and China officially issued an administrative code of Sansha City. So all this activity can enhance China's administrative and jurisdiction over the Southern Sea. And from the last year, from the 2024, China have conducted the marine study and survey on the South China Sea and published a series of national level report on the natural ecological environment of the Coral Sea. And right now, China have released 4 reports, and including five features in the South China Sea: the Second Tom Shoal, and Scarborough Shoal, and the Sandy Cay, Whitsun Reef, and the Sabrina Shoal. So all this activity, all this operation, and help make China's claims in the South China Sea is more concrete and have made strengthen China's jurisdiction. My second view is China's and the maritime action at sea right now focus on keeping the status quo. But this status quo is in China's view. That means that before the 2002 DOC signed, China accepted the status of the more than 14 islands and reefs have occupied by Vietnam, Malaysia, and the Philippines. And so China taking the policy of shelving the dispute and take no action about these disputed island reefs. But when we talk about the Second Tom Shoal conflict with the Philippines, and when the Philippine tank landing ship and Sierra Madre landed on that Second Tom Shoal in 1999, China didn't see that landing is a kind of occupation. But China accepted that situation. But when the Philippines tried to reinforce that ship and trying to make some construction activity, China thinks the Philippines is trying to change the Second Tom Shoal from an uninhabited island into a permanent inhabited garrison. And China thinks is very against the DOC, because in the DOC Article 5, that's very clear, and the regulation, and all parties should refrain from action of inhabiting on the presently uninhabited islands, reefs, and features, and something like that. So China didn't accept that. So that's the most important reason why China did very tough action in the Second Tom Shoal to intercept the Philippines' construction and maybe in the future to building a garrison. And on the Scarborough Shoal, and China take control from the 2012, and after that, and China think and that's a status quo, and after more than the last 10 years, and when the Philippine Navy and the Coast Guard and the fishermen trying to return to the Scarborough Shoal, China take a very tough action, and including the announced territorial baseline. And from this year, and the Chinese Navy, Air Force, and the Coast Guard have conducted the routine control over the Scarborough Shoal. And I think all these activity shows China trying to log in full control of the Scarborough Shoal. But all this operation and all this activity is in a way of self-restraint. Yeah, and maybe in the future I will mention that. And for other uninhabited reef, as I said, China accepted the DOC's Article 5, and just like Sabrina Shoal and the Sandy Cay and the Whitsunday Reef, something uninhabited reef, and China want to maintain this reef in uninhabited position. Maybe that's the most important reason why China firmly protected the Philippine Coast Guard vessel and entered and stayed in the lagoon of the Sabrina Shoal last year from April to September. Yeah, and China trying to prevent the Philippines and make the uninhabited Sabrina Shoal into a permanent garrison. So all this action China trying to do is to maintain the status quo, and as some foreign reporters think, afraid China will conduct the construction in Scarborough Shoal. I don't think so, and maybe, and until right now, the DOC is China pay attention to that. And the last point, I think the Chinese policy on the South China Sea and right now is stick to the bottom line of preventing the conflict. And in my view, China's South China Sea policy have followed two clear lines. Firstly, defending island sovereignty is reactive, and the second is maintaining stability is a proactive choice. And China's maritime right protection in the South China Sea is mainly carried out by the Coast Guard right now. As you have, Harrison have just said, and the Chinese Coast Guard is conducting more and more law enforcement operation in the Coast Guard in the South China Sea. But there's very few to see Chinese Navy, because China think use the Navy is very maybe tough and maybe very easy to escalation some situation. So in China's view, this is another kind of self-restraint. As the Philippines have always insisted that the tank landing ship Sierra Madre is an active service warship in the second term shore. But until right now, there's only Chinese Coast Guard and some maritime militia have deployed to conduct monitor, patrol, and intercept. There's no Chinese Navy involved that. And from Chinese view, and using Coast Guard to contact the Philippine warship, and there's another kind of self-restraint. And I will not emphasize that China's growing maritime power gave it more confidence to protect its maritime right at sea in the South China Sea. But all your monitor, all your research would be find China is very cautious to use the Navy, to use the military power. But right now, the Coast Guard is the most you have seen activity in the South China Sea, and all the operation, I think, is basically the principle of the armed conflict and the proportional, the minimum, all this the principle of the armed conflict. I would like to stop here and waiting for the discussions. Thank you.
All right, thank you. Lan Huong, I'll turn to you to close this out before we open it up for Q&A.
Thank you. Thank you very much. So first of all, I would like to thank the CSIS for sending a kind invitation, so I have a chance to speak in the panel on the legal development and dispute management. And because I'm the last speaker, so I do agree with some observation by the previous distinguished speaker before me. So here, I would like to share over the course of 2024 in the first half of the 2025, the South China Sea witnessed several recent developments, including in the legal front. And here I would like to give some 4 points. First of all, is many of the South China Sea claimants have had legal action to protect their claim and the right in the South China Sea. In the presentation by Isaac and Jackie, you mentioned on the Philippines two new legislation acts on the maritime zone in Archipelagic Sea Lane Act, and also some legislations from the China. Here I would like to share one more recent development from the legal domain. Last summer in June and in July 2024, Vietnam and Philippines have two submissions on the extended continental shelf beyond 200 nautical miles to commissions on the limit of the continental shelf. And so now in the region, there are some countries who submitted this portfolio on the extended continental shelf. For example, Malaysia has a joint submission with Vietnam in 2029, a separate submission in 2019. Philippines has in 2024, and Vietnam has 3 submissions. So with this submission, we can see that the South China Sea, the pictures of maritime claim and the limits of claim of maritime entitlement by the country is more clearer. So this is the first legal recent development. The second I would like to say regarding to China legal actions in the South China Sea over 1 year. You mentioned on the baseline system in the Gulf of Tonkin and also on the Scarborough Shoal, and China released also the standard name for the 64 maritime features in the South China Sea as the move attempt to assert its position in the region. And here I would like to talk more on the China claims in the South China Sea, because from my perspective, the maritime claims by China is the basis for and the legal foundations for their unilateral actions and the gray zone operation in the regions. The China, as we know that now China maintain the positions like the 9 or sometimes the 10-line claims. Recently, they maintain and assert the claim based on the positions on the Nan Hai Chu Dao, and as the legal foundations for this claim, they use the law, and you can see that they use the lawfare tactics by interpreting the provisions. If we look into the first, the 9-line claim in 2009, they only use the map, but without clarification. But now they use the legal, argument and counter-argument to protect the claim. And in Isaac's presentation, you mentioned on the argument that they say that the continental state can draw a state baseline around the outlying or offshore archipelago. And recently, I looked into some recent notable by China in the submission in CSIS, and they used some argument to protect the historical rights. Here, I can quote that they say that repeated reference to the historical base or historical title in UNCLOS demonstrates the respect of the UNCLOS for historical rights. From my perspective, viewpoint, I think it's a kind of reinterpreted provisions in the UNCLOS, because if we look to the tribunal award, the judge, the arbiter said that for the maritime feature in the South China Sea, the continental state cannot draw the state baseline around the outlining archipelago. And in one very, the critical studies by the Chinese societies of the international law, they give a list of some countries as a state practice to use the baseline around the outlying archipelago. But in fact, some countries like Australia or France, they reject this kind of argument. And second, for the historical rights in the arbitral ruling, they say that for the countries who become state members of the UNCLOS supersede the historical rights. So that's why I should say that the kind of argument or counter-argument by China is not according with the international law, including the UNCLOS. The third one I would like to share in terms of legal development in the South China Sea is very linked to the submissions by Vietnam and the Philippines last year. Because if we look at in the history for the periods of 2009 and 2011, and in the period of 2019 to 2022, we can say that there were some diplomatic note battles between the countries like claimants and also the outside stakeholder in the South China Sea. And now it's the same situation. If we look at the submission by Vietnam and the Philippines, we can see some claimants they circulate their diplomatic note like Vietnam, like Malaysia, like China as well, as the South China Sea claimant. And for South China stakeholder, Isaac mentioned on the U.S. reaction. In December 2024, the United States have circulated 3 note verbal to reject the excessive claim by China with the very technical and explanation based on the limit in the sea. I think it's very comprehensive positions by the U.S., the United States. And in the early of 2025, 3 more countries raised voice, the E3, like France, Germany, and the United Kingdom. They circulate as well the diplomatic note, and they to raise their voice on the legal and the long-standing legal positions on the South China Sea. And if we compare the contents of the diplomatic note, they reject the excessive maritime claim by China, including the 9-dash line or the Nanhai Chudao, and they do not agree with the kind of argument I mentioned before, like the continental state can draw the state baseline around the offshore archipelago, or no reasons for the historical rights. So, and one more in the UK, Germany, and France diplomatic notes, they mention also the law, the regulation and enforcement by the coastal state and flag state must fully comply with international law, including the UNCLOS. Then the fourth recent development in the legal front I would like to share here is the regarding to the joint development ideas. Here, if we look at some very recent statement by the country between China, for example, between China and Indonesia, and in the joint statement between China and Indonesia mentioned on the one of the element making draw the attention from the international observer is relating to the component like area, joint development in area of overlapping claims. And second, in the joint development, joint statement between Brunei and China mentioned on the mutually agreed area, and some international analysis say that these should take into considerations on the overlapping area here, because Indonesia, even they are not they are non-claimant in the South China Sea, but they have the policy on they reject 9-dash line. You can see the position in different diplomatic note. So that's why here I should say that South China Sea become one of the ground for testing well for the rules-based order in the maritime domain, and because in the world, in the connected world, the peace and stability in the South China Sea will link to the peace and security in the region, so in the world. So through some recent legal development, I would like to have some take away. First, coastal states use law to reinforce their maritime claim. However, coastal states must comply, must interpret and apply international law, particularly the UNCLOS, in good faith, because it's very important for the international treaty. And the coastal state cannot reinterpret provision in a selective way. Second, if we look at the diplomatic note pattern on the South China Sea issue, we can, and we have the comparisons, we can see that most of the diplomatic note raised voice against the excessive maritime claim by China. And one of the legal basis for these rejections is based on the UNCLOS. So here we can remind that the UNCLOS is the constitution for the sea, so and manage all activity and matter at sea. And here the international community voice and concern is very significant and crucial for rules-based order at sea. And third, regarding to the joint development, it could be an options for the dispute management, but back to the UNCLOS, any idea and proposals of provisional arrangement or joint development must be based on legitimate and lawful claim in accordance with the UNCLOS. I stop my presentation here. Thank you very much.
All right, thank you very much. So we've got just under 10 minutes for questions. I see, so if you are in the room and you have a question, please raise your hand. I see one over here and one over here. So we've got a microphone coming over there. So if you wouldn't mind just introducing yourself, name, affiliation.
Hi, good afternoon. My name's Nick Ackert. I'm the Deputy Director of Research at the Asia Group, and I have a question for Isaac. One thing I really appreciated about this discussion is I think all of our panelists pretty systematically laid out a menu of options for recourse when confrontation arises, whether legal, phone ops, paramilitary activities, other sorts of things. And I think the question I'd like to hear more about is how do you all see the interaction of these various tools? And are there any patterns that have started to emerge? Do we notice the use of some tools in some context, but not in others? And what might that say about how all the claimants are responding to the latest activities around Scarborough? Thanks.
I'll take a quick stab at this, but certainly would welcome my co-panelists to join. I think you're right that the claimants have been testing out various tools to, I guess you could say, counter Chinese operations in the South China Sea to assert their own claims. And I suppose I would consider the legislative actions that I mentioned to be part of that toolkit. And for the purpose of this panel, was focusing there, but you certainly can consider some tactical level innovations that I think I would defer to my Filipino colleague to discuss some of the things that Philippine law enforcement and naval vessels as well as civilians have undertaken, to my mind, to sort of meet China at a threshold of escalation that one could argue has been manageable and achieved certain goals. For example, the resupply of the garrison on Second Thomas. I guess I'd throw in there transparency as one of the key tools, and I think the way I was shading in my comments is I think developing higher levels of interoperability, jointly exercising some of the key capabilities that might prevent the seizure of an island or the occupation of one of the unoccupied features strike me as, you know, a more advanced version of that type of interoperability. And there's certainly a bunch of other lesser tools out there. But as I said, I think there's genuinely a strategic challenge here, leaving aside whether or not this or that tactic is effective, which is that China has been making significant progress, especially in the South China Sea, and we could talk about broader maritime space as well, in terms of what they've often called effective control or actual control, to the point that even if you are able to achieve certain of your goals, say in the example of the Philippines being able to resupply Second Thomas or maybe even reinforce the structure there, the water space is still very, very challenging in all of these areas in ways that it wasn't before. We had a discussion about why China hasn't been contesting Vietnamese buildup of its features, and one of the positive explanations was, well, there are too many of them, and that certainly sounds plausible on its face, but I actually think that the capacity to sustain law enforcement vessels, and let's include tens of thousands, if not more, fishing vessels that are potentially deployed, gives China a scale advantage and ability to be present at lots and lots of different disputed features that I think is really, really difficult to contend with. And I don't think there is a sort of a counter that employs that level of scale. And so I think we really are still in search of a strategic vision about what you're going to accomplish if China is going to continue to achieve effective control. I guess just the last thing as I closed on, it's possible that China's reached some sort of natural threshold of levels that it can press and coerce other claimants without resorting to lethal force. But that doesn't mean that, as they've done, I'd say, in the last year since the really escalatory potential of that Second Thomas standoff, to ratchet down a little bit and not press that envelope quite as aggressively, but still achieve some operational goals. So let me defer to my co-panelists to see if there are any other tools out there that they find more effective.
Thank you for the question. And I would just like to add that based on my observation, the pattern here isn't so much in one particular method, but rather a quality to that method. I observe that the options that are currently on the table, at least from the Philippine side, is that they all share the common feature of being closely consistent with international law. All of our actions or options right now are on the basis on the rule of law, anchoring it on specific provisions of UNCLOS, invoking dispute settlement under the UNCLOS, patterning it under things which are unquestionably legal under international law. I find that it's easier to get international buy-in and support when it's on the basis of shared legal values. So I think it's very strategic on the part of the Philippines to ensure that it is acting above and beyond question in that regard. It is also evident, based on the significant increase in partnerships, international partnerships that the Philippines has been getting over the last couple of years, more defense arrangements with new, up until that point, I guess, quiet supporters of the Philippines have sort of come forward now. It's much easier, like I said, to sort of support when the actions are something that these countries recognize as also binding and applicable to them as well. We have more military exercises, again, reflecting these shared legal values that the Philippines is emphasizing. I also want to point out, because I forgot to mention this during my remarks, that one of the other tools that the Philippines is sort of leaning heavily on right now is in the realm of information and data. The Philippines is investing heavily in maritime domain awareness, also gathering support from partners in this regard. There's a lot of action right now in sort of shoring up Philippine surveillance capabilities. Again, to reinforce the idea that Philippines is very, very careful right now to base actions on law, but also on facts. And having greater capability for MDA and having all of this information on the table to sort of reinforce that. Thank you.
All right, I think we have time for one more question from the floor, if anyone would like to. Sorry, I think we've got.
Thank you. My name is James Borton. I'm with Johns Hopkins University. I'm a senior fellow there at the Foreign Policy Institute, and I also established the South China Sea Newswire. I was very pleased that several of the panelists brought up a subject that I've been writing about extensively, related to environmental security and how we can find common ground through potential marine science cooperation. Also invoking indirectly, what is it, Article 124 of UNCLOS, which really calls for this common area of cooperation in terms of marine conservation. So my question to any of the panelists, and I also give credit to the courage displayed by our Chinese guest and panelist, Mr. Liu, this morning, in joining us. Perhaps he'd like to address this, is what is the role, or what role can science diplomacy play in not only tapping down the rising tensions, but creating this kind of universe of common ground that is shared by most of the marine scientists from the claimant nations? So any of you, but I welcome response. Thank you very much.
All right, thank you. So a question on science diplomacy and what role that might play. So would anyone like to take a stab at that?
Oh, yeah. And, may I just very quick, and China have done something and on the marine environmental protection, and just like I had said, and China have released and full report about the natural resources of the environment in the coral reef, and if you read the report on the 5 features, including 5 features, only the second on shore have some damage about the environment, but another 4, the inhabited feature have maintained very original. And I know we have no much time, but I may just emphasize one point, and many countries criticize Chinese land reclamation and construction have damaged the coral reef, and but while aboard the landing the Fair Cross Reef, and I know there's only China constructed 5 kilometers square about the Fair Cross Reefs, but you know the Fair Cross Reef Lagoon is about 120 kilometers square. So all the Chinese construction is only less than 5% of the lagoon. Another 95% is remained very original. And so I think we can try to find many in the environmental sphere and conduct some protection in joint, yeah. And sorry, I have no time. And yeah, thank you.
Thank you, Mr. James Bolton. And regarding to the question on the marine environment protection and scientific diplomacy, I do agree that nowadays the scientific diplomacy is very important, because the science should give the quota state to have the real data and available data to know the resources or what is going on in the maritime domain. I would like to link to some proposal by Isaac and Jackie before, when they mentioned on the BBNJ, for example, because in the BBNJ, There are four thematic issues, including the marine genetic resources, environmental impact assessment, or the transfer technology and capability building, and also for the MPA for area based management tool, and to make this issue to be after the BBNJ enter into forces. Science plays a role very important because we can know what is in the sea, and so here I think the scientific diplomacy one under the Article 123 unclosed. There are also the provision regarding to the cooperation between the countries, including the marine environmental protection, and also for the maritime scientific research is also the option for the countries in the South China Sea, because if you look in the geographic characteristic in the South China Sea, it is a semi-enclosed sea, semi-enclosed sea. So that's so it's also for the legal basis. The country, coastal state in the region can have a chance to cooperate in this field. However, I think the capabilities of the country is very important because science related to the science. So the countries need the expertise and also the expertise and also the technology as well. So that's why I think scientific diplomacy is a good choice for the coastal states to do more and further in the future. Is my own perspective. Thank you.
All right. Well, thank you to this wonderful panel. I've written like pages of notes, so this is always a very illuminating session. I'm thrilled to share the great news that we will be rescheduling a little bit, and I think we're going to be headed straight to lunch after this session. So lunch is right out there. I'd like to just give a round of applause for this panel.